Hey folks, James Abrenio coming to you from Abrenio Cho. We are a Northern Virginia personal injury, medical malpractice, and criminal defense firm located in Fairfax, Virginia. I wanted to address a question that I'm getting a lot from potential clients for medical malpractice cases. And the question goes something like this: James, I believe I have a medical malpractice. I believe this healthcare provider committed malpractice. And I can tell you, I believe that because another doctor or another medical provider down the chain of my treatment is criticizing that prior provider's care. And they are saying to me, hey, potential client, that is medical malpractice. You need to get a lawyer. And so they say to me, James, we've got this other provider that's willing to testify, and isn't my case a slam dunk? So first of all, when I hear this, it's never a bad thing. I'm always pleased to hear when I'm evaluating whether or not there's a medical malpractice case, whether or not we can take it. It's always useful to hear that other healthcare providers, subsequent healthcare providers, have criticized the concerning behavior that led you to believe that you had a medical malpractice case. It's always helpful for them to give the client a little more guidance as to the questions they should be asking, particularly what they may have, that other provider may have done wrong, a clear and concise understanding of why the standard of care was breached. But also what I have noticed in practice is when it comes down to actually reaching out to that provider, having them go on record, having them willing to testify, it can be very difficult for those subsequent providers to actually testify against a fellow doctor here in Virginia. And in a lot of ways, it makes sense for a couple of reasons. One, nobody really likes to testify or go against a fellow professional within your world, right? So if you have a doctor that practices at X practice, but they see Dr. Y at Z practice at local conferences and continuing educational courses, and they're now later being asked to testify against that person in court, it can be very uncomfortable. So from a practical standpoint, that's why it may not be as useful as we hope. Secondly, unfortunately, sometimes I see where the subsequent healthcare provider will be criticizing another provider when they're not really in the position from a court perspective to actually testify and to be qualified as an expert witness. And in order to understand this, I wanted to look at Virginia law and a relevant Virginia statute that helps explain, because the statute's very clear as to when an expert can testify against another expert in Virginia about medical malpractice. And so this is Virginia Code Section 581.20, a standard of care in proceeding before a medical malpractice review panel. So in any proceeding before a medical malpractice review panel, or in any action against a physician, clinical psychologist, clinical social worker, licensed professional, podiatrist, dentist, nurse, or other healthcare provider to recover damages to a left have been caused by medical malpractice, or the acts or omission so complained are alleged to have occurred in this Commonwealth, the standard of care by which the acts or omission are to be judged shall be to the degree of diligence practiced by a reasonably prudent practitioner in the field of practice or specialty in the Commonwealth, and the testimony of an expert otherwise qualified as to such standard of care. And in the statute, if you look, it goes on to give more guidance as to, well, what expert actually qualifies. And so let's see, it goes on to say any healthcare provider who is licensed to practice in Virginia shall be presumed to know the statewide standard of care in the specialty or field of practice in which he is qualified and certified. This presumption shall apply to any person who, but for lack of a Virginia license, would be defined as a healthcare provider under the statute, provided that such person is licensed in some other state of the United States and meets the educational requirements for the licensure. So this is talking about experts and medical providers from other states. Goes on, an expert witness who is familiar with the statewide standard of care shall not have his testimony excluded on the ground that he does not practice in this Commonwealth. A witness shall be qualified to testify as an expert on the standard of care if he demonstrates expert knowledge of the standards of the defendant's specialty and of what constitutes what conduct conforms or fails to conform to the standard of care, and if he has an active clinical practice in either the defendant's specialty or a related field of medicine within 1 year of the alleged act or omission. So what that statute's essentially doing is it's saying, look, if you have a provider that is critical of a prior provider, saying, look, that prior provider, that prior doctor, that prior orthopedist, whatever, committed malpractice, we think that doctor committed malpractice. In order for that provider that is telling you that other provider committed malpractice, they've got to be properly qualified in order to testify in court, even if they want to. And so what this is saying is they have to know Virginia's standard of care, and they either have to have an active practice in that actual field or a related field within a year of the alleged incident. So what that means really is you can't have like a primary care doctor testifying against a brain surgeon, right? It's got to be, and that's just a really kind of a general example. But what is related or not is going to be very fact specific. So if you have an orthopedist going against an orthopedist, clearly that's the same field. But let's say you have an orthopedist, and then you have I'm trying to think, a podiatrist, for instance, something like that, where it's not exactly online. Those things have to be litigated, and there are some clear-cut cases where the courts have defined and some that are not. But that being said, when you're going to me and you're saying, James, I've got this other provider telling me that my doctor or whoever messed up, we also have to consider what that subsequent provider's expertise is, because they may, even if they're willing to, they may not be qualified to testify in court against your doctor. And I'll tell you, a lot of times what we end up having to do, my number one concern is doctors in Virginia don't want to testify against other doctors, or let's say your provider doesn't qualify as a related or same practice. Oftentimes we have to go out of Virginia to find doctors out of state that are aware of Virginia's standard care of practice in that particular field, that they're properly qualified and they have the educational credentials. We even have to go to the Virginia Medical Board to get a letter saying that they would be otherwise qualified to practice in Virginia. And they have an active clinical practice within a year of that negligence. So when clients tell me, I've got a provider saying that another doctor or another provider messed up, I prefer that. It's useful, if nothing else, especially in the records, especially if they're writing in the records, that can be useful, because even if we end up having to get a subsequent expert, our expert can also use records to help form their own opinions. So they'll look at prior treatment records, not only the treatment of the doctor or the provider that we have concerns about, but subsequent care to see exactly what happened to form their opinion, to ultimately make their opinion. Now, they obviously can't just parrot another provider's opinion. They have to have their own independent review of the case and own independent opinions, but it's useful. And oftentimes also by them giving the client language to help us understand, we can get a clear theory of what the malpractice is. Because at the end of the day, what I will say is medical malpractice cases here in Virginia are very complex. We as attorneys need to be able to communicate very clearly the theory of the malpractice in order to understand the case, in order to properly investigate it, in order to help us ask better questions of our own experts, but ultimately in order to convince a jury, because juries will hear from multiple expert witnesses in a medical malpractice suit. The defendant will always, or not always, but usually be able to find some expert that supports their opinion. And so the clearer we can get about what happened and why it was malpractice, the better. So if you're having treating providers, even if they're not ultimately able to testify in court, but giving you theories as to what's going on and giving you clarity, the sooner we can get that, the better. Now, again, just going back to what the question is does that mean that you've got a slam dunk case? It does not. Just because a doctor or a subsequent provider is telling you it was medical malpractice, that's not, you automatically win. but it is useful information. You definitely want to talk to your attorney about that. And with that being said, this video is for informational purposes only. You can't just rely on it. If you have a potential medical malpractice case or a loved one has a potential medical malpractice case, feel free to reach out to us, ask us questions. We get a lot of calls about medical malpractice, or comment below. But, if it's dealing with your particular case, I always tell people, you want to maintain confidentiality. This is not attorney-client privileged, and so you don't want to be making public statements. So reach out to us if you have a potential case. If you're just watching this and you have questions, feel free to comment below. And then certainly I'm always trying to create content, so maybe I can do a separate video on that. So thank you, everyone. Wish you guys the best. Take care.